Welcome to the overview of Section 504 of the Rehabilitation Act. Today's training will provide a basic understanding of Section 504's legal background, eligibility requirements, accommodations, and specific DCPS processes. So what is Section 504? First of all, it is part of the Rehabilitation Act enacted by Congress in 1973. This act ensures that individuals with disabilities are not discriminated against in any programs or services that receive public funds. This includes public schools, and so as a school district, we must work to ensure students are able to access their education and do not suffer from discrimination within our schools. In 2008, the Americans with Disabilities Act of 1990 was amended. This amendment changed the definition of disability and impacted how students are found eligible through Section 504. We will discuss some of those differences throughout this training. DCPS's current forms and processes align with this amendment that took effect in January of 2009. Section 504 is overseen by the Office of Civil Rights in the U.S. Department of Education. This is a different department than the one that oversees special education, and Section 504 has different grievance processes as well. While DCPS has a three-step internal grievance process, including an impartial hearing, a parent or student is always permitted to file a complaint with the Office of Civil Rights, and can even file civil lawsuits if a student does not receive the protections allowed to them under the law. It is important for school staff to realize that as district employees, we all have an obligation to identify and evaluate students who may have a disability. This includes students who do not qualify for special education, but may have a disability that qualifies under Section 504. It is better to refer a potential student than to miss addressing a specific student's needs. To recap, Section 504 is a federal law that provides protection to students based upon their disabilities. Section 504 is most concerned with ensuring access to education. We need to remember that there is a child find component to Section 504 as well as for special education. Let's move on to eligibility. How is a student eligible for Section 504? First of all, a student must have a physical or mental impairment. Secondly, that impairment must substantially limit at least one life activity. Both of these requirements need to be in place for a student to be eligible. If a student has a physical or mental impairment that only mildly impacts a life activity, they would not qualify, even if the student did have an impairment. For example, a student with allergies that does not require medication and only occasionally affected the student would have a mild impact and would not qualify for Section 504. We will talk more specifically about each of these qualifications in the next few slides. As you can see with this slide, the definition of physical or mental impairments is quite broad and is not even limited to those listed on the slide. This is different from special education, which has specific and limited categories for eligibility. As a result, we need to broaden our understanding and realize that almost any physical or mental impairment may qualify for Section 504 if it substantially limits a major life activity. In most cases, diagnoses in the Diagnostic and Statistical Manual of Mental Disorders will help determine if a student has a mental impairment that qualifies. If there is a physical impairment, we will depend upon the student's medical provider to give the diagnosis. In 2008, the definition of life activities was expanded. As you can see, there is a variety of life activities that can be limited by a student's disability. The ones that were just added to the slide were ones that were added in 2008. While some of these items can seem fairly self-explanatory, some need a little more explanation. For example, operation of a major bodily function includes functions such as, but not limited to, the immune system, digestive system, circulatory systems, or endocrine systems. So the identified impairment does not have to have an outward impact on a student, but can impact internal functions. It is important to note that a student may only need to have one life activity substantially limited to qualify for Section 504. A student may qualify even if learning is not impacted. In fact, this is one of the biggest differences from special education, which looks for documentation of an educational impact. Under Section 504, we are looking at how much a life activity is impacted. So when considering life activities, it is important to realize that you cannot consider mitigating factors. This means that if a student is on medication, you have to consider how the life activity would be impacted by the impairment without that medication. For example, a student who has diabetes must be viewed in terms of how the diabetes would impact the student without insulin. A student with hearing difficulties must be considered without the use of the hearing aid. The law goes even further to state that we must consider eligibility without considering learning behavioral modifications. For example, a student with ADHD who is able to control attention issues with movement breaks every 15 minutes must be considered as if they did not have that intervention. While we do not consider mitigating factors while considering eligibility, we will consider those same factors later when determining what accommodations, if any, are needed. This is an excerpt from DCPS's eligibility form, which looks at the extent to which a student's disability impacts a major life activity as compared to the general population. Section 504 teams will go through the whole list of life activities and determine if the life activity is impacted and to what extent. Now that we know how to determine eligibility, we need to discuss who determines it and what information is needed. The 504 team should be made up of people who know the student, someone who understands the related evaluations, and someone who understands the necessary accommodations. You do not need to have the same people at each 504 meeting, but rather ensure that the team is made up of people who will have the relevant and necessary information. The screen is showing you some of the people who you may want at the meeting. The team should have a variety of sources of information to determine eligibility. Here is a list of potential sources. The important thing to remember is that you want to make an informed decision and that all the information needs to be at the meeting. We want to make sure we are making eligibility determinations based upon documentation and reports, not upon promises of future documentation from a doctor or other professional. So what do you do if you don't have enough information? Please determine what information is needed, obtain consent if DCPS will be conducting any evaluations or screenings, and potentially obtain a release of information that allows the school to help obtain the information from the student's medical providers. Then reconvene when you have that information. Please note that temporary impairments do not qualify under Section 504. If the impairment will impact a major life activity for 6 months or less, then the student does not qualify. This most often comes up around DC CAS when a student breaks an arm and can't write. In this case, we have a temporary impairment form that schools complete that allow the school to make an accommodation during the DC CAS, such as providing a scribe. That form is available online. Schools should assist their students with temporary impairments, but a Section 504 plan is not required. However, intermittent disabilities would qualify. For example, sickle cell anemia does not always impact a student, but when a student has a sickle cell crisis, there are substantial limits to their life activities. Therefore, a student with sickle cell anemia may qualify for Section 504. As a quick note, if you have a student with medical conditions that requires that others outside of the nurse know about the student's condition, the student may be eligible for Section 504. If you are convening a 504 meeting about a student with a medical condition, ensure that the nurse is present and can work with the medical providers to ensure all necessary medical orders are available and on file at the school. To recap, eligibility is based upon a student having a physical or mental impairment that substantially limits a major life activity. You determine substantially limits by comparing to the average person in the general population. A team with people who know the student best and who can assist with evaluations or appropriate accommodations must consider a variety of information and should reconvene if enough information is not available. Mitigating factors cannot be considered for eligibility, and temporary impairments do not fall under Section 504. Now that we have looked at how to determine eligibility, we'll move on to accommodations and what works under 504. Generally, when we consider accommodations, we are looking at what needs to be in place for the student to be able to access his or her education. We are looking to accommodate the student, not to provide specialized instruction or changes to the curriculum. Those types of changes would generally fall under IDEA. When considering accommodations, the team must consider how the accommodations address the specified disability, be above the average, and be clear and specific. For example, providing extra time for every student on a Section 504 plan does not meet those characteristics, nor does it make sense. A student in a wheelchair may need extra time to travel between classes, but may not need extra time to actually complete tasks. A student with ADHD may need extra time to complete tasks, but the team should be clear about what they mean by extra time. Does the student need an extra day to complete class assignments? Does the student need time and a half on exams? Being clear and specific with each accommodation and ensuring that it directly relates to the student's impairment will ensure that the plan is tailored to the specific student's needs. The team should use all information at the table to decide which accommodations best meet that student's needs. Generally speaking, students who qualify under Section 504 will not be receiving direct instructional services of a specialized nature. That being said, we have provided consultations to students who need OT or PT support. It is better to involve the professionals who understand the particular area of concern to determine what level of support, if any, is needed. If a student really needs direct services, it may be appropriate to consider special education as opposed to Section 504. In some cases, the direct service may be needed only when the student leaves the school building. For example, a dedicated nurse to travel with a student who is going on a field trip and needs access to a nurse for insulin shots or monitoring of a feeding tube. However, that same student may not need a dedicated nurse during the school day. Please note that students who need speech are always served through special education and can receive a speech-only IEP and should not receive speech through Section 504. When considering accommodations, the team should consider areas outside of the general classroom and think about any times when the student may have difficulty accessing the school day. In addition, students may require specific testing accommodations, transportation, assistive technology, or changes to the discipline policy. State whether any accommodations are needed for each 504 plan. Please note that OSSI provides guidance on appropriate testing accommodations, and the team should consider their manual, available online, in order to make the best decisions regarding that area. This may seem obvious, but Section 504 accommodations are not optional. Once the plan is written, it is a legal document, and all affected staff members must implement the plan, and the team must re-meet to make any changes to the accommodations provided. It is possible for a student who has a disability that substantially limits a major life activity to not need accommodations in school. In these cases, the school notes that fact and agrees to revisit if needs for accommodations arises. For example, a student who takes medication for ADHD may not need any accommodations while on their medication, but when they are not on their medication, the school may need to put different accommodations in place. Or a student may have learned how to adapt with assistive technology and does not need any additional support. Finally, when considering disciplinary actions for students, schools must realize that a student with a 504 plan must have a manifestation determination meeting anytime that student will be expelled or suspended for more than 10 days. The manifestation determination meeting will be documented in the district's discipline tracking system. To recap, when considering accommodations, schools should consider all areas of the school day. Accommodations need to be clear, specific, and targeted to address the specific disability. In each school, there is a Section 504 coordinator identified by the principal. This person receives training and support from the district-level Section 504 coordinator. However, all school staff should understand their responsibilities for Section 504, including child find obligations, as well as implementation of Section 504 plans. After each 504 meeting, the school-based 504 coordinator will ensure that all relevant staff and the parents receive a copy of the finalized plan, as well as to ensure that the plan is implemented in the school. Also, there are specific processes for submitting forms to the DCPS central office, which must be followed in a timely manner. A Section 504 plan must be reviewed annually, and eligibility must be reviewed every 3 years with up-to-date documentation. A common question often arises around what to do when a student transfers from another school. In all cases, the school should implement the plan until they were able to convene a Section 504 meeting. For students who have been found eligible within DCPS and who have a current and complete Section 504 file, the team should meet to review the plan and revise as needed to ensure that the students' needs are being met in their current environment. For non-DCPS schools, such as charter schools or out-of-state schools, the team will need to start with eligibility and then decide on a plan if found eligible. Thank you for viewing this overview of Section 504. We hope that you have a basic understanding of Section 504 and how it can be used to assist students with disabilities in our schools. If you need more information, you can either reach out to your school's Section 504 coordinator, the district Section 504 coordinator, or read the materials available online. Thank you.